as Fonua Field in the Southern Ijo local government area of Bayelsa State. According to the claimants, they signed a collective bargaining agreement, CBA, with the first defendant on the 28th of November 2011, which was acknowledged by the second defendant as the guarantor of the first defendant and the claimant's recruiter, that on the 16th of January 2012, there was an explosion on board KS Endeavor, which was occasioned by the second defendant's refusal to heed the claimant's warnings concerning an observed gas leakage. The claimants lost their belongings to the explosion before being evacuated to Fonua Flow Station and later to Apoi Flow Station before being taken to Warri and kept at Exter Hotel, where they were addressed by the officials of the second defendant. That when the first defendant failed to make any commitment to the claimants, their union wrote to the first defendant on the 30th of January 2012, but the first defendant responded that their appointment expired on the 17th of December 2012, pursuant to the collective bargaining agreement, and agreed to pay them 2 months' salary, which they rejected via the union's letter of 22nd of March 2012. They then demanded for the following from the first defendant: A, 1,500,000 naira for repatriation; B, 1.5 month gross salary per year of service per staff; C, 8 million naira as ex gratia per staff; D, 200,000 naira for lost personal belongings as a result of the explosion; E, 1 month gross salary per year of service in lieu of notice per staff; and F, continued payment of salaries until the dispute is resolved. The claimants pleaded further that as a result of their complaints and protests to the office of the second defendant in May 2012, the first defendant paid them 3 months' salary, which did not meet their expectations, thereby prompting them to write to the Ministry of Labor on the 11th of June 2012 through their union. The ministry held a meeting with the parties on the 14th of August 2012, where the first defendant offered to pay them the sum of 10 million naira to all the claimants, which they rejected. The parties met again on the 5th of September 2012, when the first defendant upped the offer to the sum of 15 million naira to all the 99 staff, which was again rejected by the claimants. The first defendant's counsel then wrote to the Minister of Labor that the claimants are not the employees of the first defendant, hence they could only be paid 3 months' salary on compassionate ground for their losses due to the explosion. That despite the series of correspondences, meetings, and interventions by different bodies and agencies, such as the police, the Ministry of Labor, the Bayelsa State Government through the Ministry of Energy, and the Special Advisor for Oil and Gas and Environment, including the JTF, which held 4 meetings with the parties, the defendants failed to pay them their entitlements, which made them to engage the services of a labor consultant, Crowder F. Okiakwe, who also wrote to the defendants, and also the Honorable Attorney General of the Federation and Minister of Justice. The Office of the Attorney General of the Federation wrote to the first defendant's counsel, who responded that the claimants are not employees of the first defendant, but that of GUS Consulting Limited, and that the claimants had been paid in line with the collective. At the meeting with the officials of the Ministry of Justice on the 23rd of October 2019, the first defendant admitted offering the sums of 10 million naira and 15 million naira as severance packages to the claimants, and also that there was no proper severance of the claimants owing to the explosion on the rig. That since the rig was completely burnt, the issue of ex gratia stated in the collective bargaining agreement should not be discussed because the first defendant suffered great loss. Now, second defendant's case. The second defendant advised that it did not recruit the claimants for the first defendant, as alleged by them, because it does not recruit workers for its contractors. That the second defendant, as part of its deliberate policy to promote local content and enhance the economic well-being of the members of its host communities, usually notifies its host communities of job opportunities, including job opportunities in the second defendant's contractor companies. When the second defendant awarded a drilling contract to the first defendant, the second defendant notified its host communities of job opportunities in the first defendant, and the host communities then nominated individuals that were interviewed and subsequently employed by the first defendant. The role of the second defendant was limited to ensuring that indigents of its host communities were considered in the first defendant's hiring process and did not influence or direct the process. That the second defendant neither employed the claimants nor transferred them to the first defendant, as they were exclusively employed by the first defendant, who deployed them to work on the KS Endeavor rig. The second defendant further avers that he neither acknowledged any collective bargaining agreement between the claimants and the first defendant, nor acted as a guarantor to the first defendant, and also did not assure the claimants that the first defendant will keep the second defendant will keep the first defendant's obligations under the collective bargaining agreement. The second defendant took all reasonable steps ahead to proper drilling processes and safety procedures in accordance with established industry practice in order to prevent the occurrence of the fire on the KS Endeavor rig. That following the incident at the rig, the second defendant provided logistical support for the safety and security of the persons who were working on the rig at the time of the incident. According to the second defendant, while it is true that there was a protest at his office in May 2012, the said protest was, however, unwarranted because there is no employment relationship between the claimants that they will be redeployed when the new rig was brought to replace KS Endeavor, as the second defendant did not employ the claimants. That the second defendant suffered great losses as a result of the incident, and the claimants are not entitled to the reliefs being sought in the suit. Now, second defendant's submissions. The learned senior counsel for the second defendant submitted these two issues for the determination of the court. One, whether the claimants prove that there exists a contract of employment between claimants and second defendant. Two, whether the claimants prove their claim to declaratory and monetary relief set in the amended statement of material facts against second defendant. The learned senior counsel to the second defendant first raised objections to the admissibility of exhibits CW2A, CW2C, CW2D, and CW2E on the grounds that the witness statement on oath of the witness made no reference to the documents. Hence, the documents were merely dumped on the court without evidential foundation with respect to their admissibility. That exhibits CW2C, CW2D, and CW2E have no probative value because they were neither signed nor dated, thereby amounting to documentary hearsay. Counsel referred to the cases of Omega Bank, Nigeria PSC against OBC Limited, where it was said that an unsigned document has no property value, and also Olu warranty against Sonola and another. Citations are provided, where it was also held that an undated document has no property value. The court was urged to discountenance the document. It is apposite to note that before arguing the two issues identified for determination, the learned senior counsel for the second defendant raised a preliminary point of law with respect to the jurisdiction of this honorable court to determine the suit against the second defendant. The point of law is whether on a perusal of the statement of facts, this honorable court lacks the competence to entertain this suit as constituted by 99 claimants making joint/collective claims over an alleged breach of employment. It was submitted on the preliminary jurisdiction to hear and entertain a suit when one, A, it is properly constituted as regards members and qualification of the members of the bench, and no member is disqualified for any reason. B, the subject matter of the case is within its jurisdiction, and there is no feature in the case which prevents the court from exercising its jurisdiction. And C, the case comes before the court initiated by due process of law and upon fulfillment of any condition precedent to the exercise of jurisdiction. Counsel relied on Madukolu and Scheme Dealing and SLB Consortium Limited against NNPC. Citations are both supplied. That the suit, as presently constituted, was not initiated by due process of law and upon fulfillment of condition precedent, thereby depriving the court of the jurisdiction to entertain the suit. It is a defect in competence and fatal to the case, which will render the proceedings a nullity, no matter how well conducted and decided. The defect is extrinsic to the adjudication, referring to the case of Skin Consult Nigeria Limited against OK, citation is given. That while the suit was filed by the 99 claimants purporting to sue through their lawful attorney, Crowder F. Okeaku, the claimants were, however, employed separately, with each of them having his own letter of employment, that the claimants were not employed jointly, referring to paragraph 2 of the witness statement on oath and paragraph 5 of the further deposition of CW1, that the 99 claimants therefore lack the capacity to jointly instru the suit, claiming lump sums because persons employed separately do not have collective rights to sue the employer. Counsel refer to the cases of CCB Nigeria PLC against Rose and Bosa against Julius Berger PLC. Citations are also supplied. It was further posited that the collective bargaining agreement, Exhibit CW2B, being relied upon by the claimants, do not avail them because an employer-employee relationship is governed by the contract of employment and not a CBA, except the terms in the CBA are expressly incorporated in the contract of employment, that the terms of the contract in Exhibit CW2A do not adopt or incorporate by reference the CBA Exhibit CW2B, particularly that clause 14 of Exhibit CW2A states that there are no collective agreements in force. Counsel referred to UBM PLC against Suarez. Citation is given that the CBA Exhibit CW2B was between the first defendant and the claimants union, the Nigerian Union of Petroleum and Natural Gas Workers, but the union is not made a party to the suit. The proper parties are therefore not before the court. Hence, the court has no jurisdiction over the matter. On this, counsel referred to MTN Communications Limited against Abia State Government. Citation is given. And also that 13.1 of the rules of this Honorable Court 2017. The court was urged to uphold the objection of the second defendant, decline jurisdiction in the matter, and strike out the suit. With respect to issue 1, it was submitted that since the second defendant joined issues with the claimants, denying that it employed or recruited them as employees for the first defendant, the burden of proof is on the claimants, who are sought to prove the allegation with admissible evidence. Learned Senior Counsel reproduced paragraphs 1, 3, and 4 of the statement of facts and paragraphs 1A, 2, sub 1, 3, 4, 5, and 6 of the second defendant's statement of defense, and also referred to the cases of Olokunlade against Samuel, as well as Emmanuel Robinson. Citations are also supplied. It was further posited that while the courts deprecate the attitude of litigants who are probates and reprobates, or is not consistent in the presentation of his case, the claimants who allege that the second defendant is their employer, stated in another breath at paragraphs 1, 3, and 28 sub 2 of the statement of facts, and also paragraphs 3 and 4 of the reply to the statement of defense, that the second defendant is their recruiter. Learned Senior Counsel reproduced some of the answers elicited from CW1 during his cross-examination and submitted that CW1 failed to prove that the second defendant is their employer or recruiter, as there is no evidence of employment contract between the second defendant and the claimants. That since the claimant's pleadings did not refer to any memorandum of understanding between the second defendant and the host communities, the reference to memorandum of understanding by CW1 in his evidence is not supported by the pleading and therefore goes to no issue, referring to the case of NDIC against Rabo Farms Limited. Citation is given. That the failure of the claimants to produce the same memorandum of understanding between the second defendant and the host communities means that they are either not telling the court the truth, or that if the document is made available, it will be against them. The court is therefore urged to invoke the presumption of withholding evidence pursuant to section 167 sub D of the Evidence Act. Counsel referred to Buhari against Obasanjo. Citation is given. That since the only letter of employment tendered by the claimants is Exhibit CW2A, belonging to the 12th claimant, indicating that the letter was not issued by the second defendant, but GUS Consulting. The claimants have failed to establish that the second defendant was a party to the contract of employment of any of the claimants. Counsel referred to B.A. Moronfola against Kwara State College of Technology, Kimde against military governor of Gongola State, and Bello against governor of Gombe State. Citations are also supplied. That it is only after the party ascertained the material fact in his pleading has proved the fact that the honor shifts to the defendant and not the other way around. Counsel referred to Saraki against Anayegun and Mr. Anete Emos Udo against Oilfield Specialists Limited. Citations are both supplied. With respect to issue 2, the learned senior counsel for the second defendant reproduced the reliefs in this suit and argued that while there are 99 claimants in this suit, only 2 testified in the claims which are personal to them, and also that it has not been shown that there is an employment contract between the claimants and the second defendant. On the claim for 12 months salary arrears in the sum of 468,306,859 naira 20 kobo, it was submitted that the claimants did not state in their pleadings that they are being owed 12 months arrears of salary or how they became entitled to 12 months salary from the second defendant. That since this claim is for special damages, it has to be strictly pleaded with particulars and proved, referring to the case of Al-Hassan against A.B. Uzaria. Citation is supplied. That the claimants failed to plead and prove with clarity the particulars of the arrears of salary as it relates to what each claimant is entitled to as monthly salary and how the amount was computed and arrived at. The court was asked to dismiss this head of claim. On the claim relating to loss of property in the sum of 49,500,000 naira as a result of the fire incident, it was posited that the claimants failed to substantiate the claim by stating what properties each of them lost and the values of the items allegedly lost. That loss of properties presupposes specific items of loss, which must be specifically pleaded and strictly proved. That Exhibit CW2C and CW2D were assigned the sum of that Exhibit CW2C and CW2D merely assigned a sum of 500,000 naira to each of the claimants without setting out the alleged properties lost by each of them and the values of the properties allegedly lost. They also failed to plead the items allegedly lost by them. Hence, Exhibit CW2C and CW2D are self-serving documents without utilitarian value as they are not signed. The court was asked to dismiss this head of claim. Counsel referred to 1G against Coastal Services Nigeria Limited. Citation is also supplied. On the claim for the sum of 99 million naira as repatriation payment, it was argued that it is the contract of service or letter of employment that governs or regulates the relationship between an employer and the employee, and also sets out the obligations or liabilities of the parties to the contract. That the second defendant is not the employer of the claimants, and also that the claim for repatriation is not found in Exhibit CW2A as forming part of the terms of the employment. To therefore base the claim on Exhibit CW2C and CW2D, which are not signed, has rendered the claim baseless. The court was urged to dismiss this head of claim. Counsel referred to United Bank for Africa PSC, United Bank of Nigeria PSC against Emmanuel Aderewaju Suarez, State versus Saidu, Bodai against Mohammed, and Aliyu against Namadi. Citations are also supplied. With respect to the claim for the sum of 1,065,000,000 naira being ex gratia payment as required under the collective agreement, it was submitted that the second defendant is not a party to the CBA Exhibit CW2B and cannot be bound by same, that only parties to an agreement are bound by the terms of the agreement, referring to the case of HNO against Julius Berger Nigeria PSC. Citation is supplied. That there is nothing in Exhibit CW2B to show that the claimants are entitled to any ex gratia payment, and Exhibit CW2C merely allocated various sums to each of the claimants as their ex gratia entitlements. That Exhibit CW2C is an unsigned document and of doubtful origin because the maker is not known. The court was urged to dismiss this head of claim. On the claim for the sum of 135,029,080 naira 61 kobo, being 1 month's salary in lieu of notice, 6 weeks gross pay, 4 months prorated, 4 months leave allowance, and 3 months end of year bonus, it was submitted that the claimants failed to establish that they are entitled to this head of claim, that the claim for income/earning or terminal benefit is a claim in special damages, which will require full particulars in the pleading as facts as may be necessary to enable the court to calculate as best and accurately as it can the actual amount due to each claimant. Counsel referred to the case of Blackwood Nigeria PSC against Omuma Construction, plead and prove how they arrived at the lump sum claimed, and Exhibit CW2E, which is unsigned, did not show any basis on how the amount was arrived at. The CW1 admitted under cross-examination that the claimants did not earn the same salary, and no evidence was given as to the salary of each of the claimants. The court was urged not to place any reliance on Exhibit CW2E because it is not signed, referring to the case of Garuba against KIC Limited. Citation is supplied. With respect to the declaratory reliefs, it was posited that the court does not exercise discretion to grant declaratory reliefs in the absence of evidence. The claimants are not entitled to any of the declaratory reliefs in the suit, referring to the cases of Ayola against Yaya and Akani against issue 2 in favor of the second defendant, and dismiss the suit with cost. It is upon defendant file a motion on notice on the 14th of March 2025, praying for an order of this honorable court, striking out the claimant's respondent's final written address, filed on the 4th of March 2025. The application, which is brought pursuant to Order 5 Rule 2, Order 45 Rules 2 Sub 2 and 3 Sub 2 of the Rules of this honorable court 2017, Section 36 of the Constitution of the Federal Republic of Nigeria 1999 as amended, and under the inherent jurisdiction of the honorable court, is predicated on the following grounds. 1. On 21st of January 2025, this honorable court directed all parties to file their respective final written addresses. 2. The second defendant applicant file its final written address on the 12th of February 2025 in compliance with the rules of this honorable court. 3. The claimant's respondents eventually filed their final written address on the 4th of March 2025. 4. By Order 45 Rule 2 Sub 2 of the National Industrial Code Civil Procedure Rules 2017, a written address shall not be more than 35 pages. 5. The claimant's respondent's final written address, which was filed on the 4th of March 2025, contains 48 pages. 6. The claimant's respondent's final written address is incompetent and liable to be struck out by this honorable court. In support of the application is an affidavit of 7 paragraphs deposed to by Clement Effiong, a litigation officer in the law firm of Aluko and Oyebode, together with a written address wherein this loan issue is identified for the cost determination. Whether the claimant's respondent's final written address filed on the 4th of March 2025 is filed in breach of Order 45 Rule 2 of the rules of this honorable court and liable to be struck out by this honorable court. It was submitted that since the provision of Order 45 Rule 2 Sub 2 of the rules of this court 2017, that a written address shall not be more than 35 pages, set out in paragraphs and numbered serially, is plain, unambiguous, and clear. Same should be given its plain meaning and enforced, because the use of the word shall does not give room for discretion. Counsel referred to Ayewumi and others against Owoni and others. Citation is supplied. The rules of court are meant to be observed and followed and not made for fun, referring to the cases of Asika and others against Atuanya, GM Owora and Sons Company Limited against Akuta, Arabella against Nike, and Ms. Eziana against Alhaji Mahmoud. Citations are also supplied. The court was urged to grant the application and strike out the claimant's final written address for being incompetent, pursuant to Order 45 Rule 3 Sub 2 of the rules of this court 2017. In opposition to the application of the second defendant, the claimant's respondents filed a 6-paragraph counter affidavit deposed by Jennifer Honoreode, together with a written address, on the 17th of March 2025. It was submitted that the second defendant only picked and chose Rule 2 of Order 45 without taking into consideration the other rules contrary to the legal position that a party should not pick and choose an aspect of a provision without looking at the entire provisions holistically. On this, counsel referred to Amine Suleiman against Tuku Adamu and NJC against Agumagu and others. Citations are also applied. The Rule 2 sub B to G does not investigate the reproduction of questions and answers of the witnesses or the quotations from relevant case law authorities as forming part of the required 35 pages, and the court should give literal interpretation to the clear words of the provisions in the interest of justice, referring to the case of Mary Guarantee Savings and Loan Limited against WBS Limited and Obolo Singer against Bayelsa State Independent Electoral Commission. Citations are supplied. It was further argued that by the provisions of Order 45 Rule 3 sub 2 of the Rules of Court, the failure to limit the final written address to 35 pages does not render the address incompetent, because the use of the word may gives room for discretion on the part of the court, referring to the cases of Abacha against Fawemi and Adeni against Akinyele. Citations are supplied. That exceeding the specified number of pages has not misled the second defendant, and the court can expunge from the claimant's address the aspects relating to the production of evidence during cross-examination and the quotations from case law authorities to bring same within the threshold of 35 pages as provided in the Rules of Court. That striking out the entirety of the claimant's final written address will be unfair to the claimants and will breach the right to fair hearing. The court was urged to treat the failure as an irregularity. Counsel referred to Adava against State and UBA PSC against Mode, as well as Bello against Yakubu and Osikoro against Ishekiri Land Trustees. Citations are also applied. It was further submitted that the final written will not double space as required by Rule 2 and is therefore incompetent, that he who comes to equity must come with clean hands, relying on the case of Adejumo against Anantegbe. Citation is given. The court was asked to refuse the application and not allow the rule of court to be used as a tool to perpetuate injustice. Counsel refers to Stella Odwa against Dobin Obaze. Citation is given. It is pertinent to note that the learned senior counsel for the second defendant filed a reply on points of law on the 4th of April 2025. It was implied that the provisions of Order 45 Rule 2 sub B to G are clear and unambiguous and should therefore be given their ordinary and literal meaning, that the claimants cannot expand or limit the interpretation of the provisions to accommodate questions and answers of witnesses or the quotations of relevant laws in the written address. Learned senior counsel referred to the case of Mobi Oil Nigeria PSC against IAL 36 Incorporated. Citation is given. That the contention of the second defendant that compliance with Order 45 Rule 2 of the rules of this honorable court is mandatory is fortified by the interpretation given to similar provision in the Court of Appeal rules, which limits the number of pages of a brief of argument, citing the case of Ecobank Nigeria PSC against Kunle, that since the claimants did not raise any objection to any irregularity in the final written address of the second defendant, but responded to it, they have waived their right to any irregularity in the said final written address of the second defendant. The court was asked to strike out the claimant's final written address. I have considered the arguments of both learned senior counsel for the second defendant and the learned counsel for the claimants, and seen that the sole grounds of the second defendant is that the court should discountenance and strike out the claimant's final written address for being incompetent, having exceeded 35 pages, as required by the provisions of Order 45 Rule 2 of the rules of this honorable court 2017. Order 45 Rules 1, 2, and 3 of the rules of this honorable court provide for the filing of written addresses as follows. 1. This order shall apply to all applications and final addresses. 2.1. Written address shall be typewritten with 14 font size of legible and readable font type of character, not cursive or italicized, with double spacing format, and printed with black ink on white opaque A4 size paper of good quality. 2, a written address shall not be more than 35 pages, set out in paragraphs and numbered serially. It shall contain A, the claim on which the address is based; B, a brief summary of statement of the facts with reference to the exhibit tendered at the trial; C, the issues arising from the evidence; D, a succinct statement of argument on each issue incorporating the authorities referred to, together with full citation of the authorities; E, a list of statutes or laws to be relied upon; F, relevant facts and facts relevant to the facts in issue; G, not contain extraneous matters. The court may discontinue the portion of the final address containing the extraneous matters. 3.1. All written addresses shall be concluded with a number summary of the points raised and the parties' prayer. A list of all authorities referred to shall be submitted with the written address. Where any unreported judgment is relied upon, the certified true copy shall be submitted along with the written address. Sub 2, failure to comply with rules 3, failure to comply with rules 2 and 3.1 of this order may render the written address incompetent. I have seen the very succinct and apt submissions of the learned SAN for the second defendant. The rules of court are not made for fun, but to be obeyed by the parties or litigants. See Mr. Lawrence Ozu and another against Mr. Simon Obidi. Citation is given, where it was reiterated that since rules of court are made to regulate practice and procedure in law courts, they are not made for fun, but must be complied with. In the case of Sakamori Construction Nigeria Limited against LSWC, citation is supplied. The Apex Court held as follows. The Apex Court held at page 393, paragraph G to H, the rules of court must be obeyed, and where there is non-compliance, it must be explained. Otherwise, no indulgence of the court will be granted. I have seen that while Order 2, Rule 2 of the rules of court, reproduced above, limits a written address to 35 pages. The final written address of the claimants, filed on the 4th of March 2025, contains about 48 pages, which is beyond the required number of pages. Having perused the said address, I have seen that about 11 pages contain reproduction of the questions and answers of the witnesses during cross-examination, which are extraneous matters not envisaged under Order 45, Rule 2, Sub 2, A to G of the Rules of Court. These portions of the address can be and are hereby discountenanced pursuant to the proviso to Order 45, Rule 2, Sub 2 of the Rules of this Court 2017. Having discountenanced the extraneous portions of the claimant's written address, I do not think that it will serve the interest of justice to strike out the said written address, because that would infringe on the claimant's constitutional right to fair hearing. I say this because the second defendant raised two very germane points of law and argued them in her final written address. These points of law relate to the competence of the suit and the jurisdiction of the court to entertain the suit, as well as objection to the admissibility of Exhibit CW2A, CW2C, CW2D, and CW2D, which necessitated the claimants to respond to the objections on the court's jurisdiction and the exhibits. Since Order 45, Rule 2, Sub 2, since Order 45, Rule 3, Sub 2 gives room for discretion in treating the failure to comply with Rules 2 and 3, Sub 1, I shall treat the non-compliance as an irregularity pursuant to Order 5, Rule 1 of the Rules of this Honorable Court 2017. Since it is a mere defect that does not affect the jurisdiction of the court to entertain the suit, this court shall not allow mere technicalities to overshadow the need to do substantial justice to the parties. See the case of Ogochukwu Nwezu against Toronto Hospital Limited and another. Citation is supplied, where the Court of Appeal held as follows on the distinction between an incompetent brief and a defective brief. And I quote, an incompetent appellant brief is one where defect touches on the jurisdiction or power of the court to entertain the brief, while a defective brief is one that is in breach of the rules of the appellate court on brief writing. The brief is merely bad, faulty, or inelegant. Therefore, a defective brief, as against an incompetent brief, is properly before the court, but has a feature or features repugnant to qualities of a good and effective brief. End of quote. In conclusion, let me make the point that the learned SAN for the second defendant, who has urged the court to discountenance the final written address of the claimants for failure to comply with the provisions of the rules of court, is also in clear violation of the same rules he is accusing the claimants of violating, while Order 45 Rule 2 Sub 1 requires that a written address must be typewritten with 14 font size of legible and readable font type or character with double spacing format. The final written address of the second defendant is straight font and is not double spaced. Since both final written addresses are in clear violation of the same provisions of Order 45 of the rules of this Honorable Court 2017, it will be unfair and unjust to discountenance that of the claimants and countenance the one filed by the second defendant. In the circumstance, the application of the second defendant filed on the 14th of March 2025, urging this Honorable Court to strike out the claimant's final written address is hereby refused. The application fails and is accordingly dismissed. This court shall place reliance on the claimant's final written address, save the portions relating to the questions and answers of witnesses during cross-examination, which have been discountenanced and expunged. Now, claimant's submissions. The claimant's counsel identified the following 4 issues for the court's determination. A, looking at the evidence before this Honorable Court, whether it is correct to say the second defendant recruited or employed the claimants and handed them over to the first defendant, and the claimants are employees of the first defendant. B, if the first defendant is the employer of the claimant, is the first defendant not bound by the terms of the collective bargaining agreement? C, if the second defendant did initially recruit or employ the claimants, handed them over to the first defendant, and co-signed the confirmation letter and collective agreement, whether by so doing and the prevailing law at the material time, the second defendant is not an implied guarantor of the first defendant and should be liable to pay the claimants their entitlement if the first defendant do not meet its obligations to the claimants. And D, whether the second defendant, having failed to ensure that the claimants were paid their entitlements by the first defendant as required by law before paying the first defendant, the second defendant is liable to pay the claimants their entitlement. It was submitted on issue 1 that since it is the second defendant who has the expertise and knowledge of oil drilling that notified the host communities of the vacancies and nominated and interviewed the applicants before handing the claimants to the first defendant, who equally interviewed them in the presence of the second defendant's representative, Kate Daniel, the second defendant was fully involved in the recruitment or employment of the claimants. That since the second defendant never denied that Kate Daniel is his staff and also did not debunk same during cross-examination, same is deemed to have been admitted and is therefore proved on the balance of probability. On this, counsel referred to Ezekiel Okoli against Mocha Finance Limited, Macaulay against Merchant Bank Limited, Salawal Motor House Limited against Lawal, Wele against Bojon Kolo, Saraki against Booker, and Adenle against Olude. Citations are also applied. That the defense of the second defendant is evasive and does not answer the case of the claimants, relying on the cases of Pasputo against Adecentro Nigeria Limited and Mogaji against Odofin, as well as Anyewu against Onuche. Citations are also supplied. It was further posited that since it is the first defendant that paid their salaries, was the end user of their services, and had the right to tell them the job to do and enforce discipline, the claimants are the employees of the first defendant, referring to the case of Oppo against NNPC. Citation is given. That since the claimants have established that they were employed by the first defendant, the court should resolve issue 1 in favor of the claimants. Counsel referred to Onduloy against Ojioko. Citation is supplied. With respect to issue 2, the learned counsel to the claimants referred to articles 4.1 to 4.4 of the guidelines on labor administration issues in contract/outsourcing in the oil and gas sector, and argued that by the provision of Section 18 of the Interpretation Act, the regulation is a law and binding on all the parties, which cannot be waived by any agreement of the parties, referring to the case of UBA against EGU, citation is given. That since the guideline uses the word shall, same is mandatory and must be obeyed by both employers and employees. Counsel referred to Futa against ASU and Okeowo against AG Ogun State. That the regulation has a constitutional force and must be complied with because it was made pursuant to Section 88 of the Labor Act, Section 5 and Section 148 sub 1 of the Constitution with respect to the powers of the Minister of Labor to act on behalf of the President, referring to the case of Phoenix Motor Limited against MPFMB. Citation is given. The court was asked to take judicial notice of the guidelines, which is a bylaw pursuant to Section 122 of the Evidence Act, and hold that the collective bargaining agreement is binding on the parties, relying on the case of Kerewi against Abraham. Citation is given. The court was asked to resolve issue 2 in favor of the claimants and hold that the first defendant is bound by the terms of the collective bargaining agreement. With respect to issue 3, it was submitted that since the second defendant initially recruited the claimants, handed them over to the first defendant, and co-signed both the confirmation letter and the collective bargaining agreement, the second defendant is an implied guarantor of the first defendant and is therefore liable to pay the claimants their entitlements since the first defendant has failed to meet its obligations to the claimants. That the second defendant should have confirmed from the employees if they had been paid by the first defendant before paying the first defendant for the contract. Counsel referred to Wanko against EDCSUA. Citation is given. And also part 4.2 of the guidelines on contract staffing and also in the oil and gas sector. And also the article Federal Ministry of Labor Guidelines on contract staffing and sourcing in the oil and gas sector by Bimbo Atilola, published in the Labor Law Review, Volume 8, Number 4, 2024, page 16. With respect to issue 4, it was posited that the provisions of the guidelines on contract staffing and outsourcing in the oil and gas sector 2011 place an obligation on the second defendant to ensure that the claimants had been paid by the first defendant before paying the first defendant for the services rendered by the first defendant. That since the second defendant failed to confirm from the claimants if they had been paid their entitlement and then deduct same from source before paying off the first defendant, the second defendant is liable for the payment. Counsel referred to Njili against Akinsu Madu. Citation is given, where it was held that where a statute directs that certain procedure should be followed, such a procedure and no other must be followed. The court was asked to resolve the issue in favor of the claimants. It is apposite to note that at paragraphs 4.01 to 4.31 of the claimant's final written address, the claimant's counsel responded to the issues raised in the final written address of the second defendant, including the objections to exhibits CW2A, CW2B, CW2D, and CW2E. On the contention of the second defendant that the claimant's witnesses did not link the exhibits to the suit and that there is no foundation linking the documents to the suit, it was implied that since the claimants pleaded facts relating to their employments and the explosion on board the KS Endeavor, the documents were properly admitted. On this, counsel referred to Dosumu against Dada. Citation is given. And order 30, rule 1 and 2 of the rules of this court. On the contention of the second defendant, that exhibit CW2A, CW2C, CW2D, and CW2E are not signed, and that the makers are not known. It was implied that the documents were pleaded and have been admitted by the second defendant in these pleadings, and are therefore admissible. Counsel referred to Ashaka Cement PSC against Asharatu Mobashurun Investment Limited, and also Blackwood Hodge Nigeria Limited against Omoma Construction Company. Citations are supplied. That since the calculations are based on the monthly salaries of each of the staff and their other entitlements as contained in the CBA, they were properly made, referring to the cases of Owena Bank against Olatunji and Intel Nigeria Limited against Bass. Citations are also supplied. On the second defendant's challenge of the jurisdiction of this honorable court, on the ground that since the 99 claimants have separate contracts of employment, they cannot sue the defendants jointly. It was implied that the jurisdiction of this court is determined by Section 254C of the 1999 Constitution as amended, relying on the case of Coca-Cola Nigeria Limited against Akinsanya. Citation is given, and also Section 14 of NECA 2006. That since the claimants have similar claims against the defendant, the suit was properly commenced by the claimants jointly, relying on the cases of Ogbulu against Zenith Bank, Gunyi, Kanu, and others against Attorney General of Cross River State, Unity Bank against Olatunji, as well as Order 13 Rule 11 Sub 1 and 2 of the Rules of Court, and Section 12 of NECA 2006. The court was asked not to allow common law rules to hinder the need to do substantial justice, referring to the case of UTC Nigeria Limited against Pamote. Citation is given. On the contention of the second defendant that the CBA is not enforceable because the claimants are not parties to the CBA, it was implied that by Article 4.1 of the Guidelines on Labor Administration Issues in Contract Outsourcing in the Oil and Gas Sector 2011, the argument that the CBA is unenforceable does not apply to employment contracts in the oil and gas sector. With respect to the second defendant's first issue, it was submitted that the case of the claimants is not that they are employees of the second defendant, but rather that by the conduct of the second defendant in the contract between the claimants and the first defendant, the second defendant should have ensured that the claimants were paid their entitlements before paying the first defendant for the services rendered to the second defendant by the first defendant, because the second defendant stands as a guarantor in the circumstances of the contract. Reference was made to Article 4.2 of the Guidelines on Labor Administration Issues in Contract Outsourcing in the Oil and Gas Sector, and also Skybank Nigeria PSC against Self Investment Limited. Citation is given. On the second defendant's second issue, it was posited that the claimants have established their case and are entitled to release so that the evidence of the second defendant's witness is contradictory and should be discountenanced, relying on the cases of Owena Bank against Olatunji and Ghana against SDP. Citations are supplied. That since the second defendant placed reliance on the supposed globally recognized international memorandum of understanding without producing same in evidence, the provisions of the guidelines should prevail over the oral evidence of the second defendant, relying on the case of Akimboni against Akimboni. Citation is supplied. On the contention of the second defendant that Exhibit CW2B is not pleaded, it was submitted that the claimants pleaded facts relating to the document, which was supported by the evidence of CW2 that the document was properly admitted, relying on the case of Usman against Garki. Citation is given. With respect to the contention of the second defendant that the claimants did not state the cause of each property loss as a result of the explosion and have therefore failed to prove their claims for special damages, Learned Counsel reproduced some of the answers elicited from CW2 during his cross-examination and posited that by Exhibit CW2D, the claimants have shown that they actually lost their property owing to the explosion, that the first defendant did not give the claimants the opportunity to sit down and itemize the items they lost, that the sum of 500,000 naira placed on each property is a mega amount considering the high cost of televisions, computers, etc., and the claim for ex gratia is calculated based on the minimum in the industry so that no one can query the basis of the claim, that the claims are within the stipulated range despite the fact that the value of the currency has dropped drastically, and the court should do substantial justice in the matter, referring to the cases of Owena Bank against Olatunji and Ayegu against Onuche. Citations are supplied, that the claimants are entitled to their claims before the court. Now, second defendant's reply on points of law. It is pertinent to note that the second defendant filed a reply on points of law on the 13th day of May 2025 with respect to the submissions of the claimants at paragraph 3.03 to 3.18 of their final written address that they were recruited or employed by the second defendant before being handed over to the first defendant. It was implied that the claimants who have the burden of proof failed to prove that the second defendant interviewed, employed, and subsequently handed them over to the first defendant. Counsel referred to VP Industries Limited against Cocoa Industries Limited. Citation is given that since the claimants admitted in paragraph 6 of the reply to the statement of defense that the staff that attended the interview came from the first defendant, such admitted fact can be relied upon by the second defendant to disprove the allegation referring to the cases of Unity Bank PLC against Denglak Limited and Alaribe against Okon. Citations are supplied. On the claimant's submissions, paragraph 3.19 to 3.23 of the claimant's final written address, that the provisions of the guidelines on labor administration issues in contract outsourcing the oil and gas sector 2011 are applicable to the case because the principal company is mandated to ensure that any money owed to a contract staff by the contractor is paid by the principal company. It was implied that the claimants are not contract staff, but full employees of the first defendant, and that they relied on Exhibit CW2A as evidence of their employment letters. That Part 4 of the guidelines applies to contract staff are not full-time employees like the claimants, that the second defendant has no obligation to confirm from the claimants if the first defendant has paid their salaries or other entitlements, and as employees of the first defendant, their salaries and other entitlements are as contained in their letters of employment and not the guidelines. Counsel referred to Ovivier against Delta Steel Company Limited. Citation is given. On the submissions of the claimants at paragraph 3.24 to 3.28 of the claimant's final written address, that the second defendant is a guarantor of the first defendant, having co-signed the CBA and the letter of confirmation. It was implied that the second defendant is not a signatory or party to the CBA, Exhibit CW2B, between the claimant's union and the first defendant. The court was asked to look at his records and discountenance the claimant's contention, referring to the case of Dagash against Bulam. Citation is given. That the sole purpose of signing it as a witness to a document is for corroboration in case of a dispute, relying on the case of Arije against Arije. Citation is given. That the mere fact of witnessing the document does not necessarily make the witness signatory of the document a guarantor to a party, because a guarantee is a written undertaking made by one person to another to be responsible if a third party fails to perform an obligation. Counsel referred to Chami against UBAPS. Citation is given. With respect to the claimant's submissions at paragraphs 4.01 to 4.31 of their final written address relating to the admissibility of exhibits CW2A, CW2C, CW2D, and CW2E, that the claimants did not need to plead evidence, but facts supporting the documents. It was implied that it is the duty of the claimants to relate the documents tendered to specific areas of their case, referring to the case of Ucha against Elechi. Citation is given. On the claimant's contention that this court has jurisdiction and competence to entertain the joint/collective claims of the claimants by virtue of Section 254C of the Constitution, or the 13 Rule 11 sub 1 and 2 of the rules of this court 2017, and Section 14 of the National Industrial Court Act 2006, it was implied that even though the claimants may have a common employer, they, however, do not have a common interest, because each of the claimants has his own letter of employment, which is personal to him. The court was urged to dismiss the suit. Now, court's decision. I have poured over the pleadings, the entirety of the evidence led by the parties, and the written submissions and authorities cited by the parties in their addresses filed in this suit. Having considered all the processes filed by the parties, I have seen that the suit can be conveniently determined on the basis of these two issues, namely, 1, whether the claimants prove that there exists a contract of employment between the claimants and the second defendant. This is drawn from the second defendant's issue 1 and the claimant's issues A, C, and D. 2, whether the claimants have proved their case to be entitled to the relief sought. Before resolving the two issues identified by the court for determination, it is apposite to first resolve the preliminary point of law raised by the second defendant, which challenges the competence of the suit and the jurisdiction of this honorable court to entertain the suit. The rationale for this is that jurisdiction, being a technical issue, must be determined before considering the merit of the suit, as any proceeding conducted in the absence of the requisite jurisdiction amounts to an exercise in futility. CJA, Adekwe, and others against Nigerian Security Printing and Minting Company Limited and others, and also Mrs. Chime Ogbeyolu Ayodele against Mr. Sule Isaac Ayodele. Citations are given, and also Shell Nigeria Exploration and Production Company Nigeria Limited and 3 others against Federal Inland Revenue Services and 1 other. Citation is given, where the Apex Court held us on the significance of the issue of jurisdiction to trial proceedings. And I quote, the issue of jurisdiction, being radical in nature, is at the very foundation of adjudication. It can be raised at any stage of the proceedings, at the trial court or even in the Supreme Court, for the first time without leave. All an appellant needs to do is to raise the issue of jurisdiction in his brief so as to give the respondent an opportunity to respond. The reason is because a trial conducted without jurisdiction is a waste of time. The whole proceedings, no matter how well conducted and decided, will ultimately be nullified and discarded. In the instant case, the issue sought to be raised as fresh issue, being one of jurisdiction, it could not be defeated by the rules of the Supreme Court. It had to be considered irrespective of the delay in filing the appeal. Opobi against Muniru and NNPC against Ohio Usele. End of quote. The gripe of the learned senior counsel for the second defendant is that since the 99 claimants were employed separately, with each of them having distinct contract of employment, they cannot sue the defendants jointly or collectively, relying mainly on the cases of CCB Nigeria PSC against Bose, against CCB Nigeria PSC against Rose, and Bosa against Juliet Berger PSC Supra. In resolving this preliminary point of law, I have carefully gone through the affirmance in the amended statement of facts filed on the 30th of May 2023, and it is glaring that even though the claimants were employed at different times with distinct contracts of employment personal to each of them, they were, however, disengaged the same time due to the fire incident on board the rig KS Endeavour on the 16th of January 2012, which led to their alleged loss of properties and their subsequent evacuation from the rig. While it would seem that even though the claimants were engaged at different times with individual contracts of employment personal to each one of them, the singular act of the fire incident, which affected all of them and which led to the disengagement of their services, obviously spurred the course of action in this suit, thereby giving the claimants a single course of action, entitling them to bring a joint suit under Order 13 Rule 1 of the rules of this court. For the purpose of clarity, Order 13 Rule 1 of the rules of this court provides as follows. Quote, all persons may be joined in one action as claimants in whom any right to relief is alleged to exist, whether jointly or severally, and judgment may be given for such claimant or claimants as may be found to be entitled to relief, and for such relief as the claimant may be entitled to without any amendment, end of quote. It is also pertinent to note that this provision of the rules of this honorable court reproduced above is in pari materia with the provision of Order 9 Rule 1 of the Federal High Court Civil Procedural Rules 2009, which came up for determination before the Court of Appeal in the case of National Electricity Liability Management Limited against Emmanuel Sunday Omotusi and 400 others. Citation is supplied, where the appellate court held that where there are no diverse interests of the plaintiffs in the subject matter of a suit, but a common interest, it is more convenient, advantageous, cost-effective, and prudent to have the issue determined in a single representative action than for each of the plaintiffs to embark on filing his own action to seek for his own relief. In that suit, the first plaintiff, Emmanuel Sunday Omotusi, deposed in the affidavit in support of the originating summons that he had the consent of the other 400 plaintiffs in the suit to depose to the affidavit. Having therefore perused the witness statement on oath of both CW1 and CW2 filed on the 28th of January 2022, I am of the considered view that since both witnesses stated clearly at paragraph 1 of their depositions that they have the authority of the other claimants to depose to the statements, the suit was properly commenced jointly by the claimants. This is to avoid multiplicity of suits by the claimants in respect of the single cause of action. See the case of Doba Hotel PSC against Mr. Abela Itio and others. Citation is given. The preliminary point of law is therefore resolved against the second defendant, and the court hereby assumes jurisdiction on the matter. Having determined the preliminary point of law relating to the competence of the suit and the jurisdiction of this honorable court to determine the suit. The cost is now clear to now consider and resolve the two issues crafted for determination in this suit. Issue 1 relates to whether the claimants proved that there exists a contract of employment between the claimants and the second defendant. The crux of this issue, as argued by the learned senior counsel to the second defendant, is that since the second defendant did not employ the claimants and is not a party to the contract between the claimants and the first defendant, the suit does not disclose any reasonable course of action against the second defendant. It is obvious from the claimants' pleadings and evidence on record that the claimants are in agreement with the second defendant that they were employed by the first defendant and not the second defendant. The contention of the claimants is, however, that since it was the second defendant that notified their communities of the availability of vacancies and co-signed both the confirmation letter and the collective bargaining agreement, CBA, the second defendant is an implied guarantor of the first defendant and should have therefore confirmed whether the claimants had been paid their entitlements before paying the first defendant for the services or contract executed by the first defendant, relying on the provision of Article 4, Sub 2 of the Labor Guidelines on Contract Staffing and Outsourcing in the oil and gas sector. I have considered the letter of confirmation of employment for the 86th claimant, Mr. Samuel Nnamdi Onkaike, which is Exhibit DW1C, and the offer of employment of the 12th claimant, Mr. Toyo Daibo, which is Exhibit CW2A, and seeing that both of them were employed by a firm known as GUS Consulting Limited on behalf of East Clear Field Offshore Design Engineering Limited, the first defendant in this suit. Even though the second defendant's representative witnessed the execution of Exhibit DW1C, the agreement is merely between the employee and GUS Consulting Limited, acting for the first defendant. The claimants describe themselves in Exhibits CW2C and CW2D as, quote, 4-day personnel on board KS Endeavor, unquote, thereby indicating clearly who their employer was. It is also obvious from the collective bargaining agreement, Exhibit CW2B, that the parties to the CBA are the first defendant / GUS Consulting Limited and the Nigeria Union of Petroleum and Natural Gas Workers of Nigeria, NOPEC. The second defendant is clearly not a party to both the CBA and the employment relationship between the claimants and the first defendant / GUS Consulting Limited, and cannot be bound by an agreement it is not a party to, just as a person who is not a party to an agreement cannot enforce it, even if the agreement was made for his benefit. A person who is not a party to an agreement can also not be made to shoulder the obligations contained in the agreement. Put in another way, just as a person who is not privy to a contract cannot sue to enforce it, a person who is not privy to a contract cannot be sued to be made liable under the contract. In the case of Akinwumi O. Alade against Ali Nigeria Limited and another, citation is given. The Apex Court put it succinctly that, quote, it is tried law that a person who is not a party to a contract cannot be held liable, end of quote. See also the cases of Honorable SMA Sunday Eyibo against Dairu Sheikh, Mojadadi, and others. Citation is given. And also Elisha Local Planning Authority against Reverend Sunday Olayide. Citation is also supplied, where the Court of Appeal held that an action which is brought by a party to a contract against a person who is not privy to the contract is incompetent for want of privity, even if the contract is made for his benefit. The claimants are also placing reliance on the provision of Article 4.2 of the Federal Ministry of Labor Guidelines on contract staffing and outsourcing in the oil and gas sector in contending that the second defendant is an implied guarantor of the first defendant. I should have confirmed whether the claimants had been paid their entitlements before paying the first defendant for the contract. I do not know how this contention will help the case of the claimants against the second defendant, since the said guidelines is not produced and tendered before the court to enable the court to interpret and apply same to the case. What the claimants tendered as Exhibit CW1J is an article published in the Labor Law Review, NJLIR, Volume 8, Number 4, 2014, by Bimbo Atilola, the managing partner of Hybrid Solicitors and the editor-in-chief of the Labor Law Review. The claimants have the sole responsibility to produce before the court the guidelines, but they have failed to do so. The court cannot speculate in the circumstance. The claimants are also pleading triangular employment in this suit, and therefore urging the court to hold the first and second defendants jointly and severally liable for the breach of the terms of employment contract. Let me make the point that from the state of the pleadings and the evidence on record, if there is a triangular employment, then it is between the claimants, the first defendant, and GUS Consulting Limited that issued the employment letters to them, Exhibit CW2A and DW1C, and also signed the collective bargaining agreement, Exhibit CW2B. It is therefore inconceivable that despite this avalanche of evidence, the claimants did not make GUS Consulting Limited a party to the suit and has decided to join the second defendant, who played no role in their employment, apart from notifying the host communities of the availability of vacancies in the bid to encourage or promote local content and to improve the economic/financial well-being of the members of the host communities. Apart from the ipsa digit of the claimants' witnesses that the second defendant interviewed and recruited them before handing them over to the first defendant, there is nothing before the court to show that they were employed by the second defendant on behalf of the first defendant. Their contention and evidence all fly in the face of documentary evidence, Exhibit CW2A, CW2B, and DW1C. They purport to place reliance on a memorandum of understanding between the second defendant and the host communities, but fail to produce them before the court. It is apposite to, at this juncture, make the crucial point that for a suit to be maintained and sustained against a party, there must be disclosed reasonable cause of action against such a party, the substance of which is a set of facts that can be proved to entitle a plaintiff to some reliefs for the injury caused. It is the wrong committed by the defendant which has caused an injury to the claimant for which he is entitled to sue for redress. It is the law that a plaintiff who brings a defendant to court must show in his pleadings not just the wrongful acts of the defendant, but also the consequential damages suffered as a result of the said wrongful acts. See the case of Mrs. Ebon, Olayinka Loye, and another against New Life Microfinance Bank Limited. Citation is given, where the Court of Appeal, per Afen JCA, stated thus at pages 33 to 34, paragraphs A to C, and I quote, in determining whether a reasonable cause of action is disclosed, the court needs only to look at the act and examine the averments in the statement of claim. Ajayi against Military Administrator Ondo State, 7-Up Bottling Company Limited against Abiola, and Otubu against Omotayo. The statement of claim must set out the legal right of the plaintiff and the obligation of the defendant. It must then go on to set out facts constituting infraction of the plaintiff's legal right or failure of the defendant to fulfill its obligation in such a way that if there is no proper defense, the plaintiff will succeed in the relief or remedy he seeks. Dr. Irene Thomas against the Most Reverend Timothy Olofosoye, Supra, Egbe against Adefarasin, Supra, and Rinco Construction Company Limited against VP Industries Limited. It is sufficient for a court to hold that a cause of action is reasonable once the processes filed disclose some questions fit to be decided by a judge, notwithstanding that the case is weak or not likely to succeed. The past weakness of the case, and or even the fact that the case is not likely to succeed, are not sufficient reasons to stop the claimant from coming before the court to determine the infraction of his rights and obligations arising from the transactions alleged in the statement of claim. The proper course for the defendant to take is to wait and take advantage of the weakness, if any, of the claimant's case when the action goes to trial. Ibrahim against Osim Supra, AG Federation against AG Abia, and Mobi Producing Nigeria Unlimited against La Cepa. End of quote. See also the Apex Court decision in the case of Chief Dennis Afo Oga and others against Chief J.I. Igbe and others. Citation is supplied. Having held that the claimant's case does not disclose any reasonable cause of action against the second defendant, issue 1 is resolved in favor of the second defendant. and it is the decision of this court that having failed to prove that there is a contract of employment between the claimants and the second defendant, this suit as presently constituted has not disclosed any reasonable cause of action against the second defendant. Having joined issues with the claimants and called evidence in the suit, the appropriate order to make is one dismissing the suit in favor of the second defendant only. The suit is hereby dismissed in favor of the second defendant only. Having dismissed the suit in favor of the second defendant only, I shall now proceed to consider issue 2 relating to the merit of the suit against the first defendant only. Issue 2 is whether the claimants have proved their case to be entitled to the relief sought. With respect to issue 2, let me state straight away that since the claimants are not challenging the termination of their employments, but asking for the payment of various amounts of money as salary arrears, loss of personal properties, repatriation allowances, ex gratia, and payments in lieu of notice, it is glaring that the claims in this suit are in the nature of special damages, which the law places the burden on the claimants to prove same by specially pleading and strictly establishing the claims with cogent and verifiable evidence. See sections 131, 132, and 133 and 134 of the Evidence Act, and the case of Suffolk Petroleum Services Limited against Adnan Mansour Nigeria Limited. Citation is given, where the Court of Appeal held as follows with regard to proof of special damages, and I quote, "It is tried law that special damages must be proved strictly. In Masters Dumex Nigeria Limited against Ogboli, the Supreme Court held that it is axiomatic that special damages must be strictly proved, and unlike general damages, where if the plaintiff established in principle his legal entitlement to them, a trial judge must make his assessment of the quantum of such general damages, and on appeal, such general damages will only be altered if they were shown to be either unjustly too high or manifestly too low, or awarded on a wrong principle. So far as special damages are concerned, a trial judge cannot make his own individual assessment, but must act strictly on the evidence before him, which he accepts as establishing the amount to be awarded. As reiterated in the Governor of Mid Western Province and others against Eluka and others, in determining compensation, a judge must take the assessment on the evidence before him and not make guesses based on matters upon which he has not received specific evidence. What is required is that the person claiming should establish his entitlement to that type of damages by credible evidence of such a damage as will suggest that he indeed is entitled to an award under that head. Otherwise, the general law of evidence as to prove by preponderance or weight, usual in civil cases, operates. It will be improper for a trial judge to award special damages on inconclusive facts given from memory, which have not been documented anywhere, and the trial judge cannot make his own individual assessment, but must act strictly on the evidence before him, which he accepts as establishing the award to be awarded. The court is not entitled to do any arithmetical calculation for the parties. In my view, there was total absence of how the sum claimed by the appellant was arrived at. Accordingly, this aspect of the issues is hereby resolved against the appellant. End of quote. See also the cases of Honorable Nze, Herbert Osuji, and Anthony Isiocha, Gonzi Nigeria Limited against Nigerian Educational Research and Development Council and others, Federal Capital Development Authority and other against MTN Nigeria Communications Limited and another, as well as MTN Nigeria Communications Limited against SCFS Limited. Citations are also supplied. One other pertinent point to note is that the first defendant, Field Offshore Design Engineering Limited, neither filed any process in the suit nor appeared before the court to defend the suit, despite the numerous hearing notices served on the first defendant. In other words, the claims of the claimants against the first defendant are unchallenged. In the circumstance of this suit, where the defendant failed to partake in the proceeding and offered no evidence in his defense, the court is permitted to accept and act on the evidence of the claimants, except where such evidence is implausible. The rationale for this is that the defendant is deemed to have admitted or accepted the case of the claimants, and there is nothing to place on the other side of the proverbial imaginary scale of justice as against the evidence of the claimants. The court is therefore entitled to act on such unchallenged evidence, except where same is manifestly unbelievable. It is therefore the view of this court that since the evidence of the claimants is unchallenged, the defendant, Field Offshore Design Engineering Limited, has admitted the claimant's evidence, and this court shall proceed to give its decision on the evidence adduced by the claimants in this suit. See the case of Broadline Enterprises Limited against Monterey Maritime Corporation, owners of MV Cape Monterey, and another. Citation is given where the apex court held as follows, and I quote, where evidence given by a party to any proceeding was not challenged or contradicted by the opposite party who had the opportunity to do so, it is always open to the court, cease of the case, to act upon the unchallenged or uncontradicted evidence before it. End of quote. See also the case of OAN Overseas Agencies Nigeria Limited against Bronwyn Energy Trading Limited and others. Citation is supplied where the apex court per Peter Odili JSC held as follows, and I quote, this affirmation was never either controverted by the appellant nor denied. It was clearly also deemed as admitted in law. Further on this point, it is firmly settled principle of law that facts admitted need no further proof, and same is deemed established. NAS Limited against UBA PS, where the Supreme Court, per Akinton JSA, held as follows. The position of the law is that facts admitted require no further proof. This court, in the case of Ofolet against State, held that where there is unchallenged and uncontroverted evidence, the court has a duty to act on it. Interestingly, this same material piece of uncontroverted evidence was picked from the witness statement of the first respondent's witness and restated by the appellant in paragraph 4.25 of the appellant's brief. This evidence was uncontroverted and still unchallenged under cross-examination. Failure to cross-examine on a matter is acceptance of the fact. See Gaji against Paye, no further proof is required. End of quote. See also the cases of Chief Taufik against Alhaji Mohamed Yahya Alayande and another, and Maxchem Industries Nigeria Limited against MF Kent West Africa Limited, where it was also held that where evidence is unchallenged, the court has a duty to act on same. It is obvious from Exhibit CW1A, CW1B, CW1C, CW1D, CW1E, CW1F, CW1G, and CW1H that the claimants made series of efforts to recover their entitlements, and it was when all these efforts became fruitless that they filed the instant suit in court. The defendant had paid them 3 months' salary out of the arrears of salary they are being owed, and also offered to pay them 10 million naira as severance package to all the 99 claimants, which was later increased to 15 million naira, but they rejected. I have carefully considered the reliefs in the suit and seen that relief 1 of the orders sought by the claimants is for the sum of 468,306,859 naira 20 kobo, being 12 months salary arrears being owed to the claimants. This head of claim is particularized in Exhibit CW2C, bearing the monthly salary of each of the claimants and the amount being owed to each of them by the first defendant. Since the claim is not challenged, I find merit in this relief, and same is hereby granted, only to the extent that it is the first defendant that is liable, since the suit has been dismissed in favor of the second defendant. Relief 2 of the orders sought by the claimants is for the sum of 49,500,000 naira for the loss of the claimant's property occasioned by the fire incident on board the rig KS Endeavor. The claimants are basing this relief on Exhibit CW2D, where they have allocated a sum of 500,000 naira to each claimant as the cost of the personal items lost by each of them. While I agree with the claimants that they might have lost their personal belongings to the fire incident, I, however, do not believe that they lost the same type of items of the same financial values. It could not have been possible. It could not have been plausible that all the 99 claimants on board the rig had the same personal items of the same values of 500,000 naira. In any case, These items lost by each of the claimants are not listed anywhere in the pleadings. The claim is not worthy of belief and is hereby refused. In law, it is not in all cases where a claimant succeeds in his case simply because the suit is not challenged or contradicted by the defendant. Put in another way, it is not in all cases that an unchallenged evidence is accepted and swallowed, hook, line, and sinker. The unchallenged evidence to be relied upon by the court must be credible and plausible. See Lufthansa, German Airlines against Robert Odiasi. Citation is given. And also Greenfingers Agro-Industrial Enterprises Limited against Musa Yusuf. Citation is also supplied. Relief 2 is therefore refused. Relief 3 of the order sought from the court is for repatriation allowances to the claimants back to their respective states of Bayelsa, Ondo, and Delta from the oil rig at Funua field. The 99 claimants have assigned a sum of 1 billion. The 99 claimants have assigned a sum of 1 million naira to each of them, totaling 99 million naira as repatriation payment, as can be gleaned from SCB CW2D. The claimants have not informed the court how they arrived at the sum of 1 million naira each as repatriation allowance, while the only two employment letters, SCB CW2A and DW1C, are silent on the payment of repatriation allowance. SCB CW2B, however, merely provides at paragraph 35D that repatriation shall be discussed at the point of exit. There is nothing before the court that a discussion was held with the union and parties agree on the sum of 1 million naira to each of the claimants as repatriation allowance. There is also no evidence of previous payment of the said amount as repatriation allowance by the first defendant. This relief is also refused. Relief 4 of the order sought from the court is for the sum of 1,065 million naira as ex gratia payment to the claimants under the CBA SBCW2B. Again, from SBCW2D, the claimants have allocated the sums of 15 million naira and 10 million naira respectively to the 99 claimants, totaling 1,065 million naira as ex gratia, while SBCW2A and DW1C are silent on the payment of ex gratia to the claimants. SBCW2B, the CBA, provides at Article 35D that ex gratia shall be discussed at the point of exit, just like repatriation payment. How the claimants arrived at the amounts claimed as ex gratia cannot be found anywhere in their pleadings and evidence before the court. It is apposite to make the point that the claims for ex gratia are in the main gratuitous claims, thereby placing a higher burden on the claimants to prove their entitlement to them, while the Judicial Law Dictionary, 2nd edition, by B.P. Ishaku at page 148, defines ex gratia as, quote, out of grace, favor, or indulgence, gratuitous, a time applied as a factor, as a favor, end of quote. The Black's Law Dictionary, 10th edition, at page 694, on the other hand, defines ex gratia as, quote, by favor, made as a favor or gift, and not because of any legal duty, not legally necessary, end of quote. And ex gratia payment as, quote, a payment not legally required, especially an insurance payment not required to be made under an insurance policy, end of quote. In the case of Peugeot Automobile Nigeria Limited against Saliu OJ and 3 others, citation is supplied. The Court of Appeal stated thus on claims for ex gratia, and I quote, what is an ex gratia? Exhibit 2 has not assigned any definition to the term. The term is Latin. It connotes something given out of grace, favor, indulgence, or gratuitous. Henry Campbell Black, author of Black's Law Dictionary, defines it as a term applied to anything accorded as a favor, as distinguished from that which may be demanded ex debito, a matter of right, end of quote. So it follows that ex gratia payment being claimed by the respondents is a payment by one who recognizes no legal obligation to pay. The way payment for ex gratia is couched in Exhibit 2, as reproduced above, appears to be binding on the appellant and therefore mandatory. On a closer examination, however, it is clear that for the payment of such ex gratia, two conditions must be satisfied. One, that it is only payable at the end of the year, and two, its payment is dependent on the extent to which the production target and other company results have been achieved. Where any or both conditions above is lacking, the company appellant cannot effect payment of any ex gratia to any employee. However, in his process of reasoning, the learned trial judge who adjudged the respondents entitled to the ex gratia payment as the respondents worked in 1986 from January to 3rd November 1986, a period of over 10 months, appellant ought to pay the ex gratia to the respondents as whatever target was made in production for the year 1986 was made with the threat of the plaintiffs. Fine, that may be so, but is that not speculative? Is that not an indication towards moral consideration? I think the echelon principle of the law, that law and morality are always poles apart, is still very much alive. The truth in this case is that payment of ex gratia is tied to the end of the year, which in normal calculation is the 31st day of December of each year. So unless where the company decides to pay ex gratia to some employees at a time different from end of the year, an employee whose employment ceases before end of the year is not in any way entitled to the company's payment of ex gratia. The respondents were declared redundant on the 3rd of November 1986. They were not therefore entitled to the payment of ex gratia for the year 1986 by the appellant. That is the true position. End of quote. Now see also the cases of Union Bank, the cases of Union Beverages Limited against M.A. Owolabi and the registered trustees of Union Bank Pensioners Association against Union Bank of Nigeria PLC and two others. Citations are both supplied. There is no evidence of custom before the court to show that the defendant previously paid the sums being claimed to ex-employees as ex gratia, and the relief is also refused for want of proof. Relief 5 of the order sought from the court is for the sum of 135,029,080 naira 60 kobo as 1 month's salary in lieu of notice, 6 weeks gross pay, 4 months prorated, 4 months leave allowance, and 3 months end of year bonus. This relief is computed and captured by the claimants in Exhibit CW2E and also provided for in Exhibit CW2A and CW2B. Since this leg of claim is not challenged and same is probable, I find merit in it and same is hereby granted. In the final result, issue 2 is therefore resolved in favor of the claimants, and the case of the claimants succeeds in part. The court hereby makes the following orders against the first defendant, Field Offshore Design Engineering Limited. 1. The first defendant is ordered to pay to the claimants their 12 months salaries being owed to them to the tune of 468,306,859 naira 20 kobo. 2. The first defendant is ordered to pay the claimants their 1 month salary in lieu of notice, 6 weeks gross pay, 4 months prorated, 4 months leave allowance, and 3 months end of year bonus, which is put at 135,029,080 naira 61 kobo. 3. The first defendant is hereby ordered to comply with the terms of this judgment within 1 month from the date of delivery, failing which same shall attract interest at 10% per annum until same is fully liquidated. The judgment is entered accordingly, and I make no order as to cost.
On behalf of the second defendant, we thank my Lord for this well-considered judgment. Having considered the pains that we've gone through.
Thank you.
Yes, sir. We are grateful to my Lord.
You're welcome, Mr. Egarim. Mr. Elenesik, Charles Ajuya, you joined us late. You are muted.
Oh, I'm sorry, my Lord. I was actually in the air, and as soon as I landed, I had to go and do some I had to go and change to be able to listen to erudite judgment as a lordship, sir. I thank your lordship, sir, for the time and all. I was going to ask that, my lord, I was going to ask that I thought you'd be entitled to cost. I don't know if your lordship will think about that, because we spent money coming, defending this case that really we're not supposed to be part of from the beginning. I
can't go back to that. You have copies of the judgment. I will send them to Yenagoa.
As copies, sir. I'm very grateful, sir, for taking your vacation time to do this. Yes, sir. Thank you very much, my lord.
You're welcome. All right. Thank you.
Bye. Thank you, sir.
Thank you.
Thank you, sir. Sir.
Leonard Silk, sir.
Yes.
Good afternoon, sir. This is Tochukwu. Okay, I'll give you a call on your mobile. I see that we still have some externals.